Okay, Mr. Gilo, are you ready with Ms. Reed's case?
Yes, sir.
Okay, we'll go on the record in People versus Reed, case number 226603. Record should reflect Ms. Reed's presence here in the courtroom today. If I could have counsel put your appearances on.
And over her appearing on behalf of the people.
Very deal on behalf of Ms. Reed.
Thank you. This is the date and time set for sentencing in this matter. Ms. Reed, have you had a chance to go through the pre-sentence report and talk to Mr. Gilo about that?
Yes.
Okay. Mr. Gilo, are there any additions, deletions, or corrections to that report?
None, Your Honor, thank you.
Any challenges to the scoring of the guideline?
No challenges to the guideline scoring.
Thank you. Ms. Bruker, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation?
Just briefly, Your Honor, MBOC is recommending essentially a straight jail sentence. Her guidelines are 0 to 3 months. She doesn't have much of a criminal history, but I think the description of what happened, the amount of drugs and the way that she had packaged them, she had 20 small bags of crack cocaine, 60 total baggies. I'm surprised she wasn't charged with possession with intent to distribute. Regardless of that, I would just ask the judge to follow, the court to follow that recommendation and to sentence her for 60 days in jail. That's all.
Thank you, Mr. Gilo.
As the prosecutors indicated, she's scores out 0 to 3 months on the charge that she pled guilty to. She has no prior drug offenses or felonies, only scoreless misdemeanors. And I'd ask the court to hold any jail over her head for those reasons. She understands that she did what she did was wrong. And she regrets it greatly, but we have to admit that she did cooperate with the jail personnel with respect to the drugs. Thank you.
Thank you. Ms. Reed, was there anything that you wanted to say today?
I'm sorry that this happened and it will never happen again.
I did read through the report, so I'm familiar with what happened in this case. And, you don't have much of a record and the guidelines are really low. If this was just a regular possession case, I would tend to agree that fines and costs would be enough in terms of punishment and deterrence. But the facts here concern me because you weren't just in possession, you had a fair amount of drugs with you, and they were packaged in such a way to really indicate that there was certainly some drug dealing activity going on, whether that was you or somebody else that you were carrying it for. But those substances were clearly being brought into this community for purposes of distribution, whether that was here or somewhere else. So I think that the facts here warrant a degree of punishment, and I think for purposes of deterrent, there needs to be a jail sentence. So I think there are some mitigating factors, again, your prior history or lack thereof, and the indications that you were doing this for somebody else and that you weren't necessarily involved in the distribution itself, just you were kind of the person transporting it. So balancing all those factors, I think a sentence in the middle of the guidelines accomplishes the goal of punishment and deterrence. And so the court is going to sentence you to 45 days in the Otsego County Jail. You do have credit for 2 days served. The court doesn't have an objection to your participation in the work camp program if you're eligible for that. And I've indicated that here on the sentencing sheet. Crime victims assessment of $130. Court costs of $325, attorney fees of $350, DNA testing fee of $60, and a $68 state cost, and that's all on the charge count 1 of possession of cocaine. As to the charge of operating without insurance, $50 state cost. You do have the ability to seek an appeal of this sentence, and you can have
you.
We are in the custody of the county at this time. People versus Dylan Allardt, case number 236520652165222 6522 and 6523. It should reflect Mr. Allardt's present here in the courtroom today. If I could have counsel put your appearances on.
Mike Bartis on behalf of the defendant, Your Honor.
Nina Brooker, appearing people.
And counsel, can you just spell your last name for me?
Yes, B as in boy, A-R, T as in tango, I-S-H.
Thank you. Okay, we're set here for status conferences in these cases. Mr. Bartish, you're probably aware, these were all bound over back in May. Courts granted Mr. Allardt a number of opportunities to obtain counsel. And then Mr. Allardt failed to appear. So there's been some delays in this matter. So the court certainly wants to get these files moving. Can you tell me where you guys are at?
I understand, Your Honor. I was brought into this case on, I believe it was Wednesday of last week. I filed the appearance. I think there's a district court matter that's still going that we're still doing. And then I filed my appearance in the other cases today. I have just gotten the discovery from, in the circuit court cases, these cases, through previous counsel. I got those on Friday. I'm trying to really kind of get myself up to speed. I've sent a couple emails to Mr. Rorrow. I think he's been busy in trial prep or anything like that. And so we haven't connected. So that's kind of where I'm trying to get up to speed. I am committed to getting these cases moving forward, the best that I can. I'm not going to try to ask for, dilatory delay or anything like that, but I'm just trying to get myself kind of caught up on it a little bit.
All right. Okay. Thank you. Ms. Brooker. People requesting any kind of in particular action here today?
No, Judge, maybe we could just set it over so that Mr. Bartish and Mr. Rorrow or myself can get him up to speed on plea offer. I wouldn't have any objections to the court proceeding in that manner.
Is the district court case, is that another felony case?
It is,
Okay.
and it's, we have a status on that case, not a status, because of PCC or whatever, on the 20th.
Okay.
And that's but that is via Zoom, is what and I'm not complaining, I'm out of Grand Rapids, so I wasn't gonna be up here in person. I was planning on doing that via Zoom.
Do you have any sense, standing here today, whether you're gonna be running a prelim on that or waiting?
I don't know yet, and the problem, because that involves about like 7 or 8, it looks like, charges of a Square device. I don't even have the records from Square. I just kind of, so I don't have an answer for you. I'm sorry. I'm trying to, Square is very persnickety about getting their records. I've noticed.
All right, given that there's still one file coming up from district court and any solution in this case, I think if there is a solution, would probably involve all files. What I'm gonna do is set this for a plea cutoff date in 60 days.
Okay.
So whatever needs to happen over the next 2 months, and again, and counsel, I'm not putting this on you, I'm putting this on your client. Mr. Allardt's more than enough time. So to the extent that you have to rush things or whatever, that's his problem, not yours. So I understand you're doing everything you can coming in late. But if there's going to be a plea, it needs to happen at that 60-day mark. If we don't have a plea at that time, then the court will set it for trial, and that's the way we're going to go. So Mr. Allardt, over the next 60 days, you need to work with your lawyer. I know Mr. Bardish is going to work hard on behalf of you in terms of getting what he needs to get from the prosecutor and other places. But when we're back, if we don't have a plea, that'll be it, and that'll be time to set it for trial at that 60-day mark. So, Ms. Bruker, do you have any objection to that?
No, Your Honor.
Mr. Bardish?
No, Your Honor, thank you.
Okay. So the next hearing will be in 60 days. That'll be set for a plea cutoff. Go from there, Mr. Bardish. Anything else I can address for your side here?
No, Your Honor, we're good.
Ms. Bruker?
No, Your Honor.
Okay, thank you. That's all for today. Next hearing set for 9:45, and so we'll take a short recess until 9:45. Okay, we're on the record in People versus Casey Bonamy, case number 216097. Like that counsel put your appearances on.
Anna Berger appearing on behalf of the people.
Carrie G on behalf of Mr. Bonamy.
Okay, this was set for 9:45. It's now 9:50. Don't see Mr. Bonamy present. There's nobody trying to connect in the Zoom waiting room. I know he was in treatment at the time of the last hearing. Mr. Gila, has he contacted you at all, or do you know where he's at?
I've had contact with him when he was in Harbor Hall. However, the last two times I called Harbor Hall and left a message with Harbor Hall, I did not get anything back from Mr. Bonham. Now I don't know if that's Harbor Hall's policy or what. And so that's basically where I'm at with it.
Okay, thank you. Ms. Brooker, did you have any additional information?
Judge, I would defer to Ms. Davis. I think she might have some additional information.
Okay,
Your Honor, he did send me an email on Friday. There's not much to the email other than he has pneumonia, but it doesn't say whether or not he's still at Harbor Hall or if they released him to get medical treatment.
okay. And he was, I mean, that was a condition of bond that we allowed him to go to Harbor Hall.
Yes.
Ms. Davis, I mean, or Ms. Brooker, either of you take any position on how you want to proceed today?
Probably a show cause, Your Honor, and just for the record, we did try to reach out to Harbor Hall too, but obviously because of HIPAA, they wouldn't give us any information about whether he was there or not.
Okay, all right, the court will set this for a show cause hearing at its next available date. I don't know if that'll be later this month yet or beginning in January, but whatever the court's next available date is, we'll set it for another show cause. And, go from there. It's all in that file. The next matter is set for 10:15. And just to give you a heads up, we received calls from both counsel and Ms. Ashton at 10:15. Requesting to adjourn or appear by Zoom, and the court denied those requests, so I don't know if they're gonna be here or not. Just give you a heads up on that, but we'll go on the record either way at 10:15 and see what happens.
I knew what you meant.
Okay, we're on the record in People versus Ashton, case number 236543. And Ms. Brooker's here on behalf of the people. This was set for a status conference today. Was set for 10:15. It's now 10:20. No one's present in person. And so just to make a record, the court received a phone call from Mr. Daly, Ms. Ashton's lawyer this morning, indicating that he had a scheduling conflict. Apparently some other case that he has. The judge changed the date and added today's date in a different court. So he called this morning indicating he couldn't make it to court today and requesting to appear by Zoom. Then the court also received a call from Ms. Ashton indicating that last night she took COVID and that it was positive, and she also requested to appear by Zoom. This matter was bound over in June. It's been adjourned. Pretty much every status conference. We had a status conference in July. No progress. Status conference in August. No progress. Status conference in October. After it was adjourned in August. No progress. Status conference in November. And then the court set at which time progress, and then the court set this status conference today. The court did indicate at the hearing in November that no further adjournments would be allowed, and the court as an in-person hearing. That notice was mailed out back on November 9th. The court indicated to staff to Daly and Ms. Ashton that I'm going to allow participation. It was set for a hearing in person, and that the court wasn't going to adjourn it further based on its statements last time. So that's where we're at now. Ms. Brooker, the people take any position either way on this?
I suggest the court issue a bench warrant just given the past history, and that we are currently scheduled for a show cause today.
Okay, so the court is going to issue a bench warrant for Ms. Ashton based on her failure to appear today. The court is also going to set this for a show cause for contempt with regard to counsel, Mr. Daly. And then Ms. Brooker, I think what I'm going to do is put this on the trial list so that we have dates coming up for that. This is the possession of methamphetamine charge. How many days of trial do you think we would need in this case?
I think we could do it in one day. It looks like a relatively uncomplicated case, and our witnesses are all law enforcement.
Okay. So the court's going to set this for a one-day trial, jury trial at its next available date. The court will set it for a final status conference 30 days prior to that trial date. That will be the plea cutoff and motion cutoff. And the court will send out notices of those dates both to the defendant and her counsel as well as the prosecution. Can you look at the ROA of this case?
In what are we looking?
Did we have a prior either November or October where the Mr. Daly also failed to appear?
It doesn't say on the November one, and you said when was the other one?
October.
Well, it says jury status conference set for show cause in person. It doesn't say if it's for the defendant or the attorney.
Okay. Okay. Thank you. Ms. Brooker, anything further for the record on this file today?
No, Your Honor.
Next hearing set for 10:30. Deputy, if you can let the jail know Mr. Rao, are you able to hear me okay?
Yes, sir.
Yes, sir. Okay. And Ms. Smith, are you able to hear me okay?
I am, Judge. Can you hear me?
Yes, thank you. Ms. Bruker, did you say Mr. Fenton?
He told me he was covering it this morning. I just sent him a message
Okay.
asking where he was. And I spoke this morning and he was aware of this hearing.
Okay. Ms. Smith, we're just waiting for the prosecutor to join in here. 1 second, please.
Perfect, thank you.
Okay, we have Mr. Fenton connected. We'll go on the record in People versus Stephen Rao, case number, several case numbers. We have file number 134686, and then we also have a new file number, which I don't believe is set for a hearing today, a 23 file number. The record should reflect that Mr. Rao is present today by video from Otsego County Jail. If I could have both counsel put your appearances on, please.
Stuart Fenton for the people. I apologize, Judge. I thought it was 10:45. That was a mistake on my part.
And Your Honor, I'm Shannon Smith on behalf of Stephen Rao, who joins us obviously from the jail. Just for the record, my client and I did talk about this motion, and we were previously able to meet by Zoom through the jail, and we would ask the court to proceed by Zoom with this motion today.
All right, thank you. Mr. Fenton, I did have a chance to review your motion. And Ms. Smith, there was no written response. Are you opposing the motion in this case?
No, I'm not opposing the motion. I did let Mr. Fenton know I had no objection to the motion, but we understood the court wanted him to file it. I would just ask that any information Mr. Fenton receives, that he would pass that on to the defense. And I already know that he will do that. And that's our position.
All right, thank you. Mr. Fenton, anything that you wanted to say as with regard to the motion?
Yeah, just real briefly, Judge. We didn't really expect opposition from the defense. We were just told to file this by a drug court, essentially. And we weren't even sure which venue. We tried to file it in district court because that's where drug court is, but they said to file it in circuit. So this is on his old 10-year-old case, and we're just seeking any information regarding his absconding. We're not seeking any information regarding treatment or anything that would otherwise be confidential. And it's obviously to assist us in the prosecution of his current CSC cases in front of you.
Okay, Mr. Fenton, then if you can submit an order, either with a stipulation as to form, from, Ms. Smith. And the court will sign that order, and then hopefully that'll be what you need to get the, information.
Thank you.
Your Honor,
And then I believe, sure, go ahead.
I'm sorry, I do have one other question. Mr. Fenton and I have talked about this, but because it's such an old case and so many things have changed over the years, but I guess we're not firm on what the policy is. Mr. Fenton and I would both like an updated pre-sentence interview. And I believe that probation is going to do that based on the emails that we've had jointly with probation. I don't know, Mr. Fenton, if you think we need to place anything on the record, but I would like to do an updated pre-sentence investigation for the sentencing on the drug case that's set for January 4th.
It's actually a weapons case, and I agree with that. And I think I communicated with probation and because I hadn't received anything and was told that they were not doing an update. So I think it would be appropriate, since it's been 10 years or so, that the court order an update.
I would
Okay,
join
so
that request, obviously.
All right, so you guys can't see her, but Ms. Davis is present here in the courtroom, from probation and parole. Ms. Davis.
Yes, we would do one. The reason it was not done today is we did not know about this hearing today, Your Honor.
Okay, so Ms. Davis is indicating on behalf of, probation that they will do an updated PSI.
Great.
Excellent, thank you so much.
All right, Mr. Fenton, anything else from the people on this, matter today?
No, thank you. Everything else has been adjourned until I believe January. So we'll see you then.
Okay, Ms. Smith, anything further from your side?
No, thank you, Your Honor, and thank you for allowing me to appear for the motion by Zoom today.
Sure. Did you want to have a breakout room with your client to speak with him today, or are you all set?
No, Your Honor, I'm all set. I have another appointment set up with him, and he knew what was happening today, so we're in good shape. Thank you.
Okay, thank you. That's all for this hearing today, and all parties are free to disconnect at this time.
Appreciate it.
Okay, thank you.
We've got somebody connected by the name of Mike. Sir, we're going to need you to go into your Zoom app and connect the audio. Otherwise, we won't be able to hear you. All right, I'm not sure who that person is. They're not connecting their audio, so I'm going to disconnect from them. Our next hearing is set for 11 o'clock, so we'll be in recess until that time. Okay, Mr. Fragel, the first case I have is People versus Townsen, Spencer Townsen.
Yes, Your Honor.
This is case number 236642. And this is your motion to withdraw, is that correct?
So, Mr. Counsel will be entering a plea. This is a jury status conference.
Oh, I'm sorry. Those are the other two files.
Yes.
Okay, gotcha. I thought they were off the same heading. Okay. So how did we want to proceed today then on this one?
There is an agreement that the defendant will plead 7 and 8, child sexually abusive material possession of, and the balance of the counts would be dismissed, Your Honor.
All right, thank you. Ms. Brooker, is that correct?
That is correct, Your Honor.
Okay. Mr. Townsend, have you had a chance to speak with Mr. Fragel about this agreement?
Yes, Your Honor.
And what he said in terms of you pleading guilty to count 7 and 8 and the rest be dismissed, is that your understanding?
Yes, Your Honor.
Okay. Is that how you want to proceed today?
Yes.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Mr. Townsend, are you currently on any kind of probation or parole?
No.
You understand that each of these counts, count 7 and count 8, both carry with them a maximum possible penalty of up to 4 years and or a $10,000 fine.
Yes, Your Honor.
And with those penalties in mind, what is your plea to each of those charges today?
Guilty.
Right now, you have certain rights. I know that you reviewed this advice of rights form, but I'm going to go through your rights with you here on the record as well. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all of those rights?
Yes.
Can you tell me what's going to happen to those rights by you pleading guilty today?
We'll lose them.
That's correct. You're waiving them and giving them up. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you would have to ask the next higher court. It's called the Court of Appeals. They could say no, and then that would be the end of any appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here in court today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty to each of these charges because you are in fact guilty of each of these charges?
Yes, Your Honor.
All right, Mr. Fragel, there's really not that many facts here in the felony information, so I'm going to ask that you ask a question of Mr. Townsen.
Mr. Townsen, were you in Otsego County on or about December 31st, 2022? Yes. And there again, on November 3rd, 2021. Yes. And during your time in Otsego County, did you possess some type of pornographic material? Yes. Did that material involve children, pre-puberty children? Yes. And did you know that you were in possession of that material? Yes. And that was abusive material, correct? Correct. That had no meaningful purpose, correct? Correct. Moving on to up to count 7. Again, on November 3rd, 2021, were you in Otsego County? Yes. And at that time, did you possess child sexually abusive material? Yes. And by sexually abusive material involving children, we mean pre-adolescent, correct? Correct. Pre-puberty, correct? Correct. And did you view that material? Yes. And did you know to be in possession of it? Yes.
All right, excuse me, Ms. Brooker, are you satisfied with the factual basis?
Yes, Your Honor.
Okay. Ms. Brooker, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Fragel, are you?
No, Your Honor.
Ms. Brooker, are the people satisfied that the court has complied with statute and court will in the taking of this plea.
Yes, Your Honor.
Mr. Fragel.
Yes, Your Honor.
Mr. Townsend, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to both. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing along with Mr. Fragel. Before you leave court today, you're going to meet with Ms. Davis. She's going to set up a time for a pre-sentence interview. And between now and the sentencing hearing, it's just important that you stay in touch with Mr. Fragel so that you're ready to go on that date. Mr. Fragel, anything else you need to address today?
No, Your Honor. Thank you.
Ms. Kruger?
No, Your Honor.
Okay, thank you, Mr. Townsend. That's all for today. And then the next case is People versus Patricia Hampshire. This is case number 226342. This was set as the set for 11 o'clock. It's now almost 11:10. I don't see Ms. Hampshire present. If I could have counsel for your appearances on.
Patrick Fragel on behalf of the petitioner and the defendants.
This is your motion to withdraw. One of them. Okay, I've reviewed your motion. Is there anything that you wanted to state in support of that? For the
No, nothing has changed since that motion was filed. Have not heard from her.
Ms. Kruger, do the people take any position?
No, Your Honor.
All right, the court finds that there are adequate grounds to allow counsel to withdraw based on the information contained within the motion. Again, the court notes Ms. Hampshire is not here today. She contests that motion, although she was provided with notice of the hearing. So the court will grant the motion. And do you have an order for that?
I do, Your Honor. May I approach?
Yes. And then the next file is People versus Nelson, case number 2. Oh, I'm sorry, back to People versus Hampshire. The court will then set this for a status conference at its next available date as an in-person hearing. And the court will provide Ms. Hampshire notice of the date and time of that hearing by mail. Next file, People versus Nelson. That's case number 226252. Counsel, appearances on in that file, please.
Patrick Fragel on behalf of the petitioner as well as Mr. Nelson.
Okay, this is also a motion to withdraw. The court's chance to review that prior to the hearing. Mr. Fragel, anything that you wanted to state for the record to support that?
No, Your Honor, nothing new to add.
Ms. Bruker, do the people take any position on that?
I don't, Your Honor. What is the first name of this defendant? I'm sorry.
Brian?
Okay, I don't take any position.
So the court will find that there are adequate grounds for withdrawal of counsel in this case. So the court will grant that motion. The court will set this for a status conference at its next available date, although the court notes that Mr. Nelson's been absconded since looks like last March. But nonetheless, we'll set it for another status conference and provide notice of that hearing to Mr. Nelson at his last known address. And did you have an order on that one?
Yes, Your Honor.
I can't hold back to you. And actually, they're both Mr. Nelson. I just noticed that.
Oh, let me. There's the correct order on Ms. Hampshire.
Nelson, I'll sign this one right here. Thank you. Mr. Fragel, anything further on either?
No, Your Honor.
Ms. Bruker?
Okay.
Thank you. And then Ms. Bruker, it looks like have counsel on the 11:15.
These need to be filed with the clerk, Your Honor.
Yes.
Stay.
Thank you. All right, Mr. Velo, are you able to hear me okay?
I am, Your Honor. Good morning.
Good morning. Okay, we're on the record in People versus Michael Baird, case number 236601. Ms. Bruker is present here in the courtroom on behalf of the people. Mr. Velo is present today by prior approval by Zoom. This is set for a status conference today, plea hearing. Mr. Velo, the court did receive a request this morning from your client to appear by Zoom. It's the court's policy not to allow defendants who are scheduled to be in person to contact the court the morning of the hearing and request to appear by Zoom. If they want to appear by Zoom, it has to be by prior written approval. So my staff instructed Mr. Baird that he needed to appear in person and that he would not be allowed to appear by Zoom. And the purpose of the court doing that is when I have in-person hearings set, there's a tendency of defendants to make their own decision about whether they want to appear or not. And so rather than allowing that, the court has a pretty stiff or solid policy of not allowing that the morning of. So with that in mind, it would be my intention to just set this for a show cause for your client for the court's next available date, at which time I would expect an explanation from him for why he didn't appear in person. He was notified that this was going to be an in-person hearing back on November 9th by mail. And so in my view, he's had plenty of time if he had a reason not to be here in person to make arrangements for that well in advance of the morning of the hearing. So I'll expect an explanation for why that didn't occur. But other than that, is there anything that you wanted to state for the record today?
No, nothing further, Your Honor. I believe that he did ask for Zoom initially, maybe a week or two ago, and it was denied. And yeah, I agree. He did get notice that it was in person today. So I will follow up with him. And do we have a date for the show cause?
I don't, but the court will send that out
Okay.
by mail as it did for today's date. Ms. Bruker, do the people take any position on this?
No, Your Honor.
Okay. All right. So if you could just let your client know, Mr. Velo will proceed at the next available date. The court again will send out notice of the date and time of that.
Thank you, Your Honor.
Okay. Thank you. You're free to disconnect at this time.
Have a great day. Thank you.
Thank you. Next hearing is set for 11:45. We'll be in recess until that time. Okay, Mr. Sandberg, are you able to hear me okay?
Hello, yes, I can hear you, Your Honor. Good morning.
Okay. Good morning. And then we have Mr. Fenton connected, and it looks like we have your client connected as well. So we'll go on the record. This is People versus Grappin, case number 073775. And if I could have both counsel put your appearances on, please.
You're muted, Stuart.
Sorry, didn't realize. Stuart Fenton for the people.
And good morning, Your Honor. May it please the court, Nicholas Somberg, on behalf of Alex Grappin, who's present by Zoom video, and we consent to this matter being heard on Zoom video today.
All right, thank you. This is a hearing on Mr. Grappin's application to set aside a conviction from back in 2007, a controlled substance related offense. With regard to the technical requirements, Mr. Somberg, was there anything you wanted to comment on with regard to that?
Yes, Your Honor, just that we did send the application to the Attorney General and the Michigan State Police. We received response back that they are not objecting and don't find any issue with his technical eligibility in his case. As we did put on our application in sections 3 and 4, he has had convictions set aside, or that the application was, yes, he has had convictions set aside, but that do not affect his eligibility as long as you are working from the most recent backwards, is how that works. But he is not currently on probation or parole. There's no other pending charges against him anywhere. And I believe that is all for the technical issues in this case.
Okay, Mr. Fenton, did the people have any objection on the technical requirements?
We do, Judge. He was convicted. Well, strike that. Let me actually, one of my arguments will be more factual. The legal one is that he was convicted in 2012 of reckless driving. And that was within 7 years of this conviction, which I believe renders him ineligible under the statute, specifically 780.621D, subsections 4C, which essentially states that for an application under section 1, which this is for a felony, court shall not enter an order setting aside a conviction unless all the following apply. And C says, the applicant has not been convicted of any criminal offense during the applicable time period required under subsections 1, 2, and 3. And I read that as subsection 1 for a felony means you have to be conviction free for 7 years. And he had that reckless driving conviction 5 years after this conviction.
All right, Mr. Somberg.
And that's a correct reading of the law, and that's why we work backwards in an expungement. So we go from the most recent backwards in somebody's record. So that reckless driving conviction was set aside on March 31st, 2022. Therefore, removing it from his record, so there is no conviction within the 7-year period, legally speaking. That's why the Attorney General didn't object, because now it makes him eligible to have the older crimes set aside.
Okay, thank you. And then, Mr. Fenton, did you have any other objections to the technical requirements?
That's my only objection to the technical requirement. And I guess that's going to be a legal issue that the court has to decide, because he was convicted at the time. So now do we count it or not, since it's been expunged?
Right.
Am I
Go ahead, Mr. Somberg.
No, I guess I just be repeating myself. But my argument is no, it's not counted because it has been set aside. It's like it was not. There's no public record of it, and I believe just by our application with the Attorney General that they would agree. They pick up on every little technicality, and they did not object to his eligibility.
So I've had this come up in a few of these cases now, particularly since the automatic into effect, that there are some of these interim convictions that are now being removed automatically pursuant to the new statute. So I've had this come up a couple of times in the last few hearings, and I've actually had the AG's office present at least one hearing arguing that that once it's expunged, it doesn't legally count for consideration of later request to expunge prior convictions, which is consistent with Mr. Somberg's argument. And in my reading of the statute is the same as the Attorney General's and as well as Mr. Somberg. So I agree with Mr. Somberg's position that under the current state of the law and the current state of Mr. Grappin's record, that it would not prohibit him from being able to have it set aside. So with no further objections as to the technical requirements, the court finds that those have been met. And so then with regard to Mr. Somberg, the final two requirements, which are the circumstances since in Mr. Grappin's behavior since the conviction, as well as the public interest. I usually don't take sworn testimony, but if you want to inquire of your client as to those two issues.
Yes, Your Honor, I do typically like to just quite briefly water you're the client on those issues.
Okay, so Mr. Grappin, if you can unmute yourself, please.
Yes,
you
Your Honor.
proceed, Mr. Somberg.
Okay, thank you. Did the court want to place him under oath or no?
No.
Okay. Mr. Grappin, first the court would like to know a couple things. Having an expungement set aside is not an automatic or a right that you have. It is a privilege that the judge that can grant you. The things that the court's going to want to know is why do you deserve this expungement? How have you changed your life? And how is society as a whole better? How is it in the best interest of society as a whole for you to have this crime off of your record? I think where you should first start is in 2007, what happened? Why did you commit this crime? And kind of go from there on how you've changed your life.
So to be quite honest, from 2007, I can't quite remember exactly what the case entails. Again, I was just a child then, but I was, obviously the wrong people, the wrong time, was mixed up with the wrong crowd. I was childish. Here we are 20 something years later. I'm almost 40 years old. I've stayed out of trouble. I'm just trying to raise a family. I'm trying to get my career furthered. Like, I mean, all this stuff to me happened when I was a kid. Like, I've stayed out of trouble. I have not been in any trouble at all since. I'm raising 4 children. I'm coaching youth football, youth baseball. I'm part of all the programs. Like, I did everything that the court required me to do, from parole to being an honored inmate to coming home and doing all the programs that they need to do. I've acquired all of the certificates that I've been asked to acquire. I mean, obviously, I'm sorry, go ahead.
No, you're good. Alex, you're doing fine. I guess I want to ask you, do you recall what your sentence was for the 2007 distribution of a controlled substance?
I believe, honestly, I cannot recall exactly.
Did you serve jail or prison?
I did do almost 2 years in prison.
Okay, and then you served parole after that, correct?
Correct. I did 18 months parole.
And you completed your parole successfully, right?
Yes, I actually gave speeches for the parole office.
And you paid all your fines and costs to the court and everybody that you owe. You have no money outstanding, correct?
Absolutely.
Since then, have you had children? Did you raise a family?
Yes, I have 4 children now.
Okay, and you acknowledge that after 2007 that there were 2 more misdemeanors, but those were driving related misdemeanors that have been set aside, correct?
Correct.
Okay. And
I'm not a criminal. I'm not, I don't have like this long lasting thing. Like, I was just wrong place, wrong time. And again, back then, like, they say you don't tell on nobody type thing. Like, that's what really got me in trouble, was just trying to be everybody's friend, I guess you could say. I mean, from where I was then to where I am now is completely two different people. I mean, I work full time. I own a company. Like, I'm trying to further myself in the carpenters union that I'm associated with. Like, I mean,
Alex, let me just ask you a couple questions to help the court. Has having this felony on your record held you back from any housing or job opportunities?
absolutely. Yes.
And you said something with the carpenters union, as it's held you back. And has it held you back from any housing, getting an apartment or a mortgage or anything like that?
Yeah, I mean, everywhere you go, they ask you if you have a felony on your record. I mean, I have no choice but to say yes. And a lot of people, I mean, they don't even question what it is or where it came from or what it, nobody gives you time to talk. It's just you have it or you don't.
Would your family be better off if you had this felony off your record?
Oh, absolutely. I can't even go on some of the field trips with my for school because of it.
So you've been blocked from going on school field trips to help other kids in the community with sports?
Yes.
Okay, got it. Your Honor, I don't think I have any further questions if the court has any.
Okay, I don't have any questions. Given the statements of Mr. Grappin on the record, Mr. Fenton, do the people take any position about whether the court should grant the relief?
I was gonna object, Judge, because he committed this crime, I think 5 days before his sentencing on the other crime that he's also trying to set aside, which is another felony drug case, which if this case gets set aside, then apparently, according to the logic that the court used, that case will get set aside as well. And he'll have absolutely no criminal record for any of this conduct. And I think it was quite an aggravating circumstance that he committed this case shortly before sentencing on another drug felony. And this one's even more serious because it involved a delivery. But given the state of affairs with our statute here and the way things have been going, and I do have some empathy for someone who has changed their life as a family, as a productive member of the community now, I'm just going to leave it to the court's discretion.
All right, thank you. Mr. Sonberg, anything that you wanted to say on behalf of your client?
And just, it just said to Mr. Fenn's point, it doesn't automatically make the next one expungable, but we will be back on January 3rd in person in Gaylord to do the next one. God willing that this one is set aside.
But legally, if this one was not set aside, he'd not be eligible to have the other one set aside.
Correct. It would block his eligibility to have to even consider the next one.
Okay. All right. Anything else you wanted to say, Mr. Sonberg?
Just, Your Honor, that he's changed his life. People make mistakes. Just a long time ago. I mean, when you have kids, you really settle down and life changes and your perspective changes. And I think that he will really benefit from having this set aside, and so will his family, and therefore so will the community, Your Honor. And we ask you that you do grant our application.
All right, thank you. I've had a chance to review the file prior to today's hearing, as well as the application. I've had an opportunity to hear from both counsel as well as Mr. Grappin on the final two requirements. First of all, the court notes, as Mr. Fenton alluded to, there has been a movement over the past several years by the legislature to make it easier for people with previous convictions to have those removed from their criminal record. And the actions of the legislature reflect an overall, I think, movement within society to make it easier for people to move on from prior convictions as long as they meet certain requirements. And in fact, it's gone so far as to automatically expunge certain prior convictions for people without even the need for a hearing. And so the court views these applications now in the context of the greater movement of our society through our legislature to make it easier. Then looking specifically at Mr. Grappin's case, these occurred when Mr. Grappin, it looks like, was about 20 years old. So certainly at a younger age where people are immature and tend to make decisions without full regard of the potential long-term consequences of those decisions. And I think that's true certainly in Mr. Grappin's case. although he has had a couple traffic incidents, he hasn't had any type of, and those traffic incidents are misdemeanors, but he hasn't had any type of, I guess, what we would consider a true criminal behavior over the past 20 years. He has moved on from this in terms of his career and raising a family. And so the court finds that his behavior and circumstances since this conviction was entered would justify having it set aside. In terms of the public interest, Mr. Grappin's indicated the ways in which this conviction in particular has held him back in terms of being able to participate in school events, coaching events, and being able to further his career. In the court's view, and again, I think in larger society's view, through the actions of our legislature, it's in the interests of the public for individuals who've gone for a period of time, like Mr. Grappin has, without repeating the kind of conduct that got him in trouble in the first place, to allow those people to fully reintegrate into society and allow them to participate in ways in which they were previously unable to because of that conviction, and in particular in ways that are beneficial to society. Certainly pursuing job and career opportunities provides a benefit to the community as a whole. And obviously involvement in youth activities certainly does. We don't have enough people willing to do that as it is, and to have somebody prevented from doing that solely because of a conviction that occurred when they were 20 years old in 2007, I think would not be in the public interest. So for all those reasons, the court finds that the grounds have been met. Mr. Sonberg, the court does have, or is in receipt of a proposed order, so the court will complete that order and sign that with today's date. And that's all I have for today. Thank you. All parties are free to disconnect at this time. That also concludes the court's morning docket. The court will be in recess until 1:30.